system signify, in the present context. Now, to understand international legal system, we will have to go a little early into the writings of a famous German scholar named Niklas Luhmann. Now, it was Niklas Luhmann who talks about law as a social system. And he says law as a social system is similar to many other social systems that exist in the society. And one of the characteristic features of law as a social system is that it has its own language of defining things. For instance, we have rights and duties. It has its own way of achieving its ends. For example, we have the criteria of attaining justice. It has its own institutions. For example, we have the judiciary, which looks into the interpretations and the new and the application of law, which is different from politics. Wherein you have political parties who create demands and in a sense who create standards. In law, it is the judiciary principally which creates the standards of law. So Niklas Luhmann says that law can be understood as a legal system, as I said earlier, because it has its own language, it has its own way of looking at things, and it has its own way of interpreting things. For example, a person kills another person on the road. Now, this is just an act of killing, and it can be interpreted variously. It can be interpreted as murder. It can be interpreted as self-defense. It can be interpreted as murder out of necessity. It can be interpreted as an accident. It can be interpreted various ways. And the various interpretations, they spring out from the law, the language that law has developed. So in that sense, law is unique from its environment. So in the environment, in a sense, the killing happens on the road, but law looks at it at the very act of killing in a very different sense. And if you ask a sociologist, the sociologist would look at it in a very different manner. Probably a political scientist would look at the very act of killing in a different manner. So that's what legal system would imply. That's the first thing. So when you look at international law as a legal system, we have to look at international law as its own defining characteristics. For example, it should have its own way of looking at things. It should have its own language. It should have its own principles. It should have its own vision for itself. It should have its own standards. So that's how we would understand international legal system. Now, interestingly, there is another scholar. See, it's not my intention to just throw the names of scholars, but there are some names which are very essential to the topic. So there is an international law scholar named Anthony D. Amato. Now, why I'm taking his name? Because he took up the theory of Niklas Luhmann, and I have shared writings of both Niklas Luhmann and Anthony D. Amato as part of the readings for this lecture. So Anthony D. Amato took up that idea of law as a legal system, and he tried to apply that very concept to international law, and whereby he argued that international law is actually a legal system. Why international law is a legal system? Because it has its own defining characteristics, which means international law is different from criminal law. It is different from constitutional law. It is different from law of evidence, or for that matter, administrative law. And how does he define? He says international law is, has certain defining characteristics. For example, is based on state consent. It is based on the equality between states. It is based on, in a sense, defining jurisdiction based on state sovereignty, based on state's interest. And it has the defining characteristic of defining nationality based on whatever the state thinks, the manner in which it wants to define it. So in a sense, international law is a stand-alone discipline which has its own way of looking at things. And that is how we will define international legal system. Interestingly, Anthony D. Amato, when he adopts the idea of Niklas Luhmann, he talks about it as international law system. Now, again, in the theme of this summer course is international legal system, and I do not think that there is any substantial difference between international law system and international legal system. So I'll be using the term international legal system, meaning it, giving it the same meaning that Anthony D. Amato gives it. Now, that's the first thing. So once we have defined international legal system, we need to understand that any system, and for that matter, any legal system, interacts with its environment. Now, how does it happen? It happens in the way, a human being interacts with its environment. A human being, for instance, takes up water. Now, water is outside the body of a human being. So you are taking water and you are drinking the water. Now, what happens to the water is not defined by the environment, but it is defined by your body. So your body tells you how it will use that water. For example, you take up food. Now, whenever you have taken up food inside, it is your body that defines what is to be done of that food, whether that food is to be converted into energy or whether that food is to be stored as a, as an energy source for future use, for example, fat. So in a sense, your body interacts with the environment, but it has its own defining principles. That's how it happens in international law as well. International law interacts with its environment and then defines for itself whether something is legal or whether something is not legal. For example, one of the recent cases is the killing of General Qasim Soleimani, the Iranian general, by the US forces in Iraq. Now, General Qasim Soleimani was representing the Iranian government, Iranian Revolutionary Guards in Iraq, and while he was going to have a meeting with the Prime Minister of Iraq, on his way just outside the Iraq airport, just outside the Baghdad airport, he was attacked by an American drone and he was killed. Now, this is just an incident. This is just like another incident that happens, that is happening around the world, another instance of targeted killing. But let us look at how international law look at it. Now, international law looks at it in a different manner. It does not define it as a simple targeted killing. It says you are targeting an official of the state in another state. So even if US and Iran are at war with each other, US is killing General Qasim Soleimani in Iraq, not in Iran. So in a sense, this gives out a very interesting, a picture. And, it's reported that this is the first instance wherein wherein a foreign official was killed through targeted killing, through targeted method in a foreign soil. Now, that's an interesting, that's an interesting case. So look at another example. The example is the South China Sea. What happens in the South China Sea? It's just a mere claim of territory by China. China is just making a claim as to its territory that, probably this territory belongs to me as well. Now, how does international law look at it? International law looks at it either as legal, whether it is justified or not, and illegal, whether it is not justified. So in a sense, whatever happens in the environment, whatever happens in the global society, what international law does is it interacts with it and tries to translate it as justified or not justified, whether it is good, whether it is legal, whether it is not legal. So in a sense, international law as a system, international legal system is interacting with its society. Now, another example, the killing of fishermen off the Indian coast by the Italian Marines. Now, that's another case wherein international law looks at the very incident of men killing other men. However, the translation is a dispute between Italy and India. So that's how international law looks at it. Probably a political scientist would look at it in a different manner, or a sociologist would look at the very same incident in a different manner. So what I'm trying to emphasize is, once you have understood that there is a legal system, you need to understand that the legal system operates within a particular environment, and it consistently interacts with the environment. Now, when the legal system interacts with its environment, it takes some things, it does not take some things. Some things it says, well, it's not the domain of law that that you should do it. That's I can give you an example on this. In 2003, when US-led coalition forces, they wanted to invade Iraq. A group of 16 professors from leading universities of England, including Professor James Crawford, Professor Philip Sams, and Professor Christian Chinkin, many leading professors, they wrote a letter in the Guardian newspaper asking the then UK Prime Minister, Mr. Tony Blair, to not, intervene in Iraq. And the argument was, well, that is against international law. You should not, invoke international law to invade another country, and that is against the international principle of, non-interference. Now, that's one way of looking at it. However, later they went on to publish an article in 2004 wherein they said our intervention in this political issue probably was too much, and probably we should not have discussed that issue from a legal perspective as professors of international law. So what I'm saying is, how law interacts with its environment is dependent on how, what the facts are and what the circumstances. Now that gives us a strong background to proceed further into the lecture. Now the second aspect of the lecture is then, how do we look at COVID? Now, as I said, the legal system interacts with its environment. So whatever is happening on the ground as part of the pandemic, as part of the COVID pandemic, is actually its environment. And then we will have to see whether this environment of COVID has first, international law thinks that COVID situation is something that needs to be addressed. The answer is yes. There are a number of international law papers that have been written on the state responsibility of China, the responsibility of World Health Organization, and many others. So that's there. The World Health Organization talking about COVID and talking, providing briefs on COVID is again a part of international law's response to COVID. Then you have a number of, uh, trade collaborations happening between countries, or for example, India sending the hydrochloroquine to US on US demand initially, and then the threat by the President Trump. Again, that is an example of international law interacting with COVID. So yes, COVID is a situation wherein international law has to address it. International law, international legal system as a whole cannot, in a sense, ignore the event of COVID. So that's the first thing. That's very clear, and that's established. The second thing is whether COVID will have any impact on international law. Now, on this, we haven't addressed the second issue yet. The second issue is, when the legal system interacts with its environment, whether the environment can bring any substantial change in the legal system, that we haven't addressed. And the answer is yes. Now, look at, and I'll give you a very real life example. Look at if someone has, watched the movie, wherein the mathematician Professor Nash was suffering from schizophrenia. The movie is A Beautiful Mind. Now, what happens in that movie? It's interesting. Whatever is happening in the environment, Professor Nash's brain thinks that there is someone after him and his life is under threat, and the security of the entire state is under threat. And because of that understanding, the behavior of Professor Nash changes. So in a sense, if human body is a system and it interacts with its environment, it is quite understandable that strong impulses from the environment can have a rippling effect on the behavior of human body. Now that is what is happening in Professor Nash's case. Similarly, from law perspective, we can look at how, the Delhi rape case. Now, what happened in the Delhi rape case? The Delhi rape case shook the entire country, and post that case, post that incident, a kind of movement began in the country, which culminated in bringing certain changes in rape law. So what does it mean? It means that not in all circumstances the legal system would be affected. However, in certain exceptional situations, something happening in the environment can impact the legal system and its behavior. Now, what we have to do now is to look at whether COVID pandemic has the ability to bring any substantial change in the manner in which we look at international law. That is the most important point, and that's what I'm going to address. Now, before we move on to COVID, let us move a little bit before the advent of COVID, and I would not take you more into history. It's like, let's start from 2017 onwards, probably 2016 onwards. And if there is a problem with the time, with locating the time, let us start with the ascendancy of Donald Trump as the president of the United States of America. Now, what is happening? With the ascendancy of Donald Trump in United States of America, a number of trends started to come out. Now, what are the trends that came out? First, as a movement against anti-globalization. Now, this anti-globalization movement is not, I'm not saying it's a movement by the people. What I'm saying is it's a movement, it's a kind of, it's a kind of response of the government to the globalization process. So what is happening is Donald Trump comes, he starts criticizing the globalization process. He starts championing the American cause, which is the national cause, and he starts talking about, we should make America great again, which in a sense calls for looking inside, not looking outside. So globalization is looking outside and integrating with the world, but the Donald Trump, brand of, nationalism is looking inside and, talking about our own interests. Now, what are the implications? Now, of course, this is only part of politics. This is not law. We haven't discussed law yet on this. So that's what happens in US. Now, similar trends start to come up in, a number of countries in Latin America as well. In Venezuela, in Ecuador, you have similar trends. Then you have trends building up in France. You have trends building up in Netherlands. Of course, the government is not in power in many of these states, but the trend is building up. And in many of the states, the government has become anti-globalization. Its stand is anti-global. It does not want to integrate in globalization process. And many of the scholars have identified this kind of a trend as a populist trend. Now, what is a populist trend? A populist trend is wherein the movement is against the establishment. Against the establishment means against the already existing structure. So if the structure is to integrate, with the world community, if the structure is to promote human rights, if the structure is to promote, greater trade, if the structure is to promote global integration, if the structure is to, you know, if the structure permits you to, or even asks you to, integrate international standards in your domestic laws, in your domestic systems, that's the populist tendency would argue in a different manner. In a sense, it would say, let us not talk about human rights as something that is applicable to us from above. We look at our own situations, we look at our own conditions, and we will decide it accordingly. That's what is happening with Trump when he's saying, well, we are going to implement more instances of torture in specific types of crimes, which goes against the international standards. This is happening when he says, the entire climate change study, the entire climate change debate is a hoax, and we are going to promote fossil fuel based industry. So he's again going against the already established notions of international discourse. Now this is all part of politics, either national politics or international politics. Now, how does it translate into law, in international law? There are instances. For example, America withdraws from TTIP, the Transatlantic Partnership. America withdraws from the Paris Agreement. Now, not only America, hold on. South Africa withdraws from the ICC. US, Russia, both unsigned. They have signed. They were not members of International Criminal Court. They had signed the Rome Treaty. They both unsigned the Rome Statute. Then you have a couple of countries which denounce the new ICSID convention. For example, Bolivia, Ecuador, they denounce the ICSID convention. Then you have a couple of countries that unilaterally withdraw their bilateral investment treaties. For example, India does it, Ecuador does it, South Africa does it, Venezuela does it. A group of, if I'm not wrong, 8 or 9 countries, they withdrew from unilaterally from their bilateral investment treaties. So the populist part of the domestic politics or the populist part of international politics has repercussions in international law. That's what is happening. International law is being affected with many of the denouncements, many of the withdrawals, and many of the challenges to its vision. For example, the vision of lowering down the greenhouse gas emissions that has been challenged by great countries. Great in the sense of economy, not in the sense of not in any ethical or moral sense. I'm not using it in that term, in that sense. So that is what is happening in international law. And when you look at these trends in international law, you go back to the debate, the initial point, whether these changes will have any impact on the international legal system. Now, remember, I have not touched the COVID thing yet. Now, scholars who are established in international law of the stature of Professor Martis Koskenemi, Professor James Crawford, and many others, including Professor Philip Alston, they are looking at these populist tendencies of the governments, and they are trying to find whether these have any impact on international law or not. For example, Professor Koskinen says that the trend that is visible in in the throughout the world of the growing populism, of the growing tendency against the already existing establishment, is nothing but a challenge to the liberal discourse of international law. That's what he uses. He uses the phrase liberal discourse. Now, what does the liberal discourse mean? He says that international law as a discipline, it developed out of the Christian traditions. And how does it develop? How did it develop? The earliest international law scholars, for example, Francisco Vittoria and Suarez, they belonged to the Salamanca University in Italy, the present day Italy. The Salamanca, University, the Salamanca School actually took up the task in late 16th century or 16th and 17th centuries. It took up the task of defining what international law should be. And it started with defining international law based on Christian ethics and morality. Now, in order to de-Christianize the entire discipline, what it did was it converted the Christian ethics into the ethics of natural law. That's how we look at the instance of jus gentium, if anyone can relate to it, any one of you can relate to it. The very idea of jus gentium in international law is an embodiment of natural law, which is rooted in Christian philosophy and ethics. Now, once we move forward and we start imagining international law as a positive law, now, one of the most important incidents when this happened is the Treaty of Westphalia in 1648, which probably many of you might not be knowing was a treaty signed between the Protestants and the Catholics. And it ended the 30 years war between them. And it defined that the relations would be based on state consent and mutual engagement. So that's how it's established. So from then onwards, international law became a positive law. And when it became a positive law, and since I'm running out of time, I'm cutting the long story short, it started to develop certain elements that would help it to sustain. And those elements were the progressive elements. It said that as international law develops, it develops in the positive direction. So which means the advent of human rights in international law is a positive development, and we should all strive to promote human rights. And that is how human rights becomes a global value. All the nations should adopt human rights movement. The human rights standards should be, in a sense, incorporated within the domestic legal system. That's how international law was. And that is how Koskinen defines it as the liberal tradition in international law. Now, coming to the period between 2017 and today, these governments, these people, they're actually challenging this entire focus of international law on liberal traditions. For example, the tradition on promotion of human rights. Human rights is a global value. Or the promotion of mutual cooperation. In a sense, every one of us should cooperate, and we should look at the world as a global community. So that is being challenged by the populist governments throughout the world, and that is how international law is being reimagined. However, as I put it in the in the synopsis that was circulated to you all, this interaction of international legal system with the environment, the populist environment, is about to bring changes in international law. And the leading scholars, Professor Philip Alston is also of the same view, that it has the tendency to bring substantial changes. And Philip Alston is talking about human rights particularly. It has the tendency to bring significant changes in the understanding of international law. However, as I mentioned again, I repeat, as I mentioned in the synopsis, the changes would not be the doctrinal changes. Doctrinal changes means these changes are not going to challenge the authority of United Nations, saying that United Nations should not be there. They are not going to challenge the relevance of treaties. That the treaty should not be there as a basis of mutual cooperation. They are not going to challenge the existence of International Court of Justice, saying that International Court of Justice should not exist. They are not going to challenge the diplomatic and consular relations, saying, for example, tomorrow that India has no right to access Mr. Jadhav in the case between India and Pakistan at ICJ. So they are not going to challenge the doctrinal aspect of international law. What they are going to challenge is the way we understand international law, whether international law is a law of different governments coordinating with each other, and these governments working on their own self-interest, or international law is a law of cooperation where all the governments, all the states come together and they try to solve global problems. For example, the problem of climate change, the problem of the issue of sustainable development, the problem of migration, the problem of movement of people, the problem of refugees. So are we going to look at it as a cooperative based system of international law, or an interest-based system of international law wherein different different states based in their own separate self-interests are interacting with each other? So leading scholars are of the view that these changes are only going to bring changes in the way we imagine international law, and it's not going to change the way in which we practice international law, in a sense, if I can use this kind of a vague classification. Now, coming to the COVID thing, what is happening with the COVID? Now, COVID is one instance which has exacerbated the populist tendencies that were there already existing throughout the world. Now, to people like Noam Chomsky, people like Klein, I think the full name is Natalie Klein. Now, these are the people, and of course, from India, Arundhati Roy, and many other people who are looking at the COVID thing very closely. They are saying that COVID, the problems that COVID throws, wherein you have to stop migration of people. So in a sense, you have to regulate the movement of people, not only across the borders, but within your domestic space as well. For example, I'm sitting in Bhopal, the weather is wonderful, but then I'm not, for example, that's not the truth though. For instance, I'm not allowed to go outside my house because there is a lockdown. So in a sense, the very instance of locking people down for between countries, not allowing them to move between countries, and also within the country, they are not being allowed to move. Now, we are not discussing whether that is positive or not whether this should be done or not. We are not discussing the merits of it. What we are discussing is the very tendency of locking people down, number one. Number two, and very especially in the case of India, the very tendency of not addressing the people who belong to the marginalized sections. For example, the labor class, the working class, the lower strata, economic strata of the society, the working class, or for example, the marginalized communities. You have Islamophobia rising up as part of this COVID thing, the Jamaat, Tablighi Jamaat, and all those entire incidents. So all of these incidents have the tendency of strengthening the state. The state becomes more powerful with respect to its citizens. The state becomes more powerful with respect to the rights of its citizens. For example, you cannot claim the right to information as you can claim it in normal times. Now, whatever be the situation, the entire region of Kashmir is under lockdown, so you do not have right to access information about Kashmir, and the people within the valley, they do not have access to information. So state becomes very powerful. It's already powerful, and the COVID situation makes it more powerful. Now, another instance can be when for instance, the drug, though Russia has already announced that we have developed a drug, but once the drug comes into the market, the issue would be the issue of access. Who will get access to the drug? We already have the question of access to the testing, the COVID testing. So in a sense, the COVID testing is quite costly and not everyone can afford it. So in a sense, state is gaining more strength, number one. Number two, market is already strengthening itself. Now, if you look at the trend of global trade, the way the global trade happens, the latest trend will show that the economic activities in global trade happening through quote unquote the channel of value chains, global value chains, or global commodity chains, GVC or GCC. This entire structure is external to the state. So in a sense, the international trade is happening not through the channel of trade, but it is happening through a network of buyers and sellers and producers and consumers. So when the market is gaining strength, number one, when capitalism is on the rise, we have already reports of it, and when state is gaining strength. Now, all of this is happening a lot in COVID. Remember, a lot of it is happening in COVID. So the strength that state gained in the beginning, it's gaining more strength as part of COVID. And this actually has the tendency of bringing significant changes in international law. Now, for instance, the issue of citizenship, and that's what the title of the paper was. I'll just briefly put up the issue because, probably I would have required more than this allotted time to discuss all of these things in detail. But anyways, as to the issue of citizenship, what are we looking at? How are we looking at citizenship in the times of COVID? We are looking at citizenship as an unequal citizenship. What does that mean? What is an unequal citizenship? Now, if you have seen in India, for instance, you have thousands of workers trying to migrate to their hometowns during the lockdown, when the lockdown was announced, and it was announced at a very short notice. You have scenes of people walking down the road hundreds of kilometers to their hometowns. You have the scene of people waiting at the bus stands in Delhi in thousands to board a bus to go to their hometowns. And then you have also the pictures of people when they are almost about to reach their home state. They are detained by the public officials and they are being sprayed. I'm using the term sprayed with the chemical so that you do not carry the coronavirus with you. Now, that's one way of looking at people. So people who are up in the economic ladder, they are getting the opportunity of being tested individually. They are getting the opportunity to move. For instance, in your own vehicles, they can move. Even I could, go to my hometown and come back because I have a vehicle. So that is happening. And with the lowest rate of the society, they are not getting that opportunity. Now, look at the other example. The use of COVID being used as a tool to create rift within the society. Now, how is it happening? The entire episode of Islamophobia that happened with the Tablighi Jamaat event, wherein you targeted a particular group of people for spreading the virus. And if you can look at the news reportings from that time, you will understand that this was an underreporting event. If I'm not wrong, I read in one of the write-ups that this instance of rising COVID cases through the people from the Jamaat is because of the testing that is happening with these people. Because the other groups of people, they are not being tested. the information that is coming out is that a particular group of people are responsible for the spread of the virus. So what I'm saying is COVID, in a sense, is giving an opportunity for the state to become more strong. The state is already a populist state. We already know Indian government is a populist government. I'm not saying this, a number of big scholars in political science, in political theory, they say that Indian government is a populist government. I can give the names. Christoph Cheferlot, he says that, India is uh, gaining populist tendency. You have Partha Chatterjee who says that, a number of people are there who say that India is a populist government. So it's going along with, US, Venezuela, Ecuador, and many other countries in the populist trend. And then due to COVID, there is an instance of unequal citizenship. You are being treated unequally as a citizen within your own state. Now, what would international law with this? What would international law do with this? The problem is international law cannot do much as of now, because the only standard that international law can create is to give citizenship. It can only ask states to give citizenships to its people. It does not have the tendency, it does not have the tools to define the manner in which the state gives its citizenship to people. So in a sense, international law as of now is blind as to this unequal citizenship between, people. How does it resolve it? We do not know. So what I'm trying to hint at is that the future of international law is going to be different in the way we see it. And COVID-19 has a big role to play in our reimagination of the international legal system as we understand it today. We are not going to look at it differently in its doctrinal sense, but I'm quite sure, and I concur with many of the leading scholars, that probably our imagination, our theorization of international law would have to be reimagined. So I rest my case here. Thank you.
Thank you so much, sir. I open the floor for questions. If anyone have a question, please ask.
Sir, before anyone asks, I think I would just like to say that why don't participants just mention their names or something in chat box, and then we can ask one by one the name, so that there is no lagging. Right? Whoever is willing to ask, he can just mention in the chat box. He can raise the hand. Right? So there will be no lagging. That way. Anyone? Mania, please.
Good morning, sir. Am I audible?
Yes, you are.
Yeah. Good morning, sir. Actually, my question is in relation to market that you were stating about, right? The marketing is strengthening itself in the times of COVID-19. But at the same time, you were mentioning about the state's role also being strengthened. So don't you think in the present times of a pandemic, the state's role is actually changing from a minimalistic state to a full-fledged welfare state, especially in relation to the force major clauses that are being invoked when it comes to the investment law in international law, right? Because many contracts have been working in the favor of the state, from where the nationals from the state where the investment had happened was in their favor and not from the foreign investors who were investing there, especially in the contractual obligations when it comes to the law, international law, whenever the foreign investment law is taking place.
Okay. So, Imran, you want me to answer this question, or you want other questions to pour in and then I should answer?
So you can answer.
I can answer this question. Okay. Thanks a lot, Manya, for this question. It's an interesting question, but I must remind the viewers how bilateral investment treaty regime, the investment law, it came into existence. It came into existence because the investors, they wanted to safeguard their own rights against this, and that is why you have the investor state arbitration. So in a sense, investment law favors the investors a lot. So it is not in the favor of the state, it is in the favor of the investor. That's how it is, model. That's the first thing. The entire bilateral investment treaty is again something under investment law is again something that favors the investor. It protects the rights of the investor, the interests of the investor, and it gives the investor the freedom to go against the state before an arbitral tribunal to seek its own interest. So in a sense it favors the investor. That's one thing. Now the other thing is, when I'm saying the state is gaining strength and the market is also gaining strength, I'm not saying that they are gaining strength at the cost of each other. I'm not saying that, number one. I'm not saying that they are competing against each other to gain strength. Number two, I'm not again saying that. What I'm saying is very clearly is they both are colluding themselves. They both are colluding with themselves. So in a sense, the state is going in the direction where, if I can use the term, the transnational capitalist class wants to take it. Now, transnational capitalist class is a term uh, that is invoked by Professor Chimney in one of his articles. So, but then he's not the first person who is talking about a transnational capitalist class. There are many scholars before him who say that the international economic system is working through a transnational capitalist class, wherein people from the upper strata, upper economic sections of the society, they are defining how the economic system should be structured and how it should work. Now, that very system is working along with the state to serve its own interests. So when you're saying that, the state's welfare measures are, growing, I do not agree to that. The welfare measures are not growing. I don't agree to that, because we have a lot of capitalist tendency being, growing up, especially in the COVID times. Now, even people like Chomsky say that a lot of, in a sense, a lot of market-driven activities would be there in post-COVID world. The market is gaining strength, and human rights would lose its relevance, the great relevance that it has today. So the welfare measures that state is doing or it is engaged in, I do not think they are sufficient enough to address this issue, because the way the modern state is structured, or the modern form of globalization is structured, it's working along with the market. That's how it is happening. I hope I have answered the question.
Thank you, sir.
Yes, can we move on to the next question, please?
One question. I guess there is no other question till now. So the
I think
question is,
I think I could, I made a very difficult presentation for people, or rather a very simple presentation.
I'm not sure, but I'm very like, this lecture reminds me of the debate that Professor Michael Sennett held, I think in one of the European countries, and the debate on the Kant's theory as to whom should be preferred to uh, giving resources of a state when there are citizens and non-citizens. For example, let's say asylum seekers or refugees. So seeing the mass migration of refugees in European countries as well as in Asia, like we have refugees in Bangladesh from Myanmar. So how should the states go in distributing the vaccine that is coming? Because in India, let's say, Poonawala said that a huge amount of vaccine will be saved for the Parsi community only, right?
Mm.
So how the state should approach in distributing the vaccine, especially seeing the impact on the refugees and asylum seekers.
See, there are many issues here, and I deliberately did not discuss the issue of stateless people, because that is a different issue altogether. I only focused on the issue of citizens. So you can only understand if the citizens are being treated differentially, if citizens are facing a differential access, a differential treatment, what will happen to stateless people who are not even citizens? So their condition is very bad. Now, coming to your question, and that is why I did not discuss it, because that will again add one more layer to what I was trying to discuss. Now, coming to your question, how states should address the issue of refugees. First, the state should recognize that refugees have rights. I don't think, especially in India, the state is recognizing it. You have the entire debate on CAA and RC is the debate of stateless and statelessness. It's all about statelessness. People, when they are going on the street and when they are, taking down, when they are protesting the very danger of being understood as or translated as or identified as stateless people. So, and why is it happening? Why state being a state citizen and not being a state citizen is such a fundamental problem? The problem is because the stateless people do not have much rights. Even if they on paper they can have rights, but in reality they do not have much rights. So in a sense, when it comes to the issue of COVID vaccine, if it ever comes up, and whether it should be distributed to stateless people and how it should be distributed, I would say the first step would be to understand stateless people as people having human rights, people having the rights to not to be detained, not to be questioned, not to be questioned because without any reason, not to be asked to show their papers or not to be marginalized. Only when you address this, the question of giving access to medicine comes up, because our system is very deeply flawed in this context. Now, coming again to the topic, I do not know what would happen to the COVID vaccine when it, for example, it reaches India. The question would be whether it goes to everyone equally or whether it is distributed differentially. So even within the citizens, I'm quite certain that everyone would not have the same access to the medicine. And why I'm saying that? Because a lot of money has been poured in to develop the vaccine, and these companies, these pharmaceutical companies, would like to reap benefits out of this, the entire vaccine, the vaccine that they have developed. So in a sense, the COVID vaccine, I don't think it can be distributed freely, or it would be distributed freely. Look at the COVID tests that are happening. COVID test is not a cheap test. It's quite, you need quite a bit of money to undertake that test, and it's not available freely. So similar, I'm thinking similar would happen to, the COVID vaccine. So access to COVID vaccine would be a big issue, number one, because of its pricing. Number two, access to COVID vaccine with stateless people within the state, that again would be an issue at the third layer. Now, I just want to highlight one more aspect on this. If any one of you has looked into the history of TRIPS and the history of it, had said that we are not going to follow TRIPS agreement because it is not in our interest. But then the pressure that developed from WTO, India had to go down and India had to accept the TRIPS agreement. So what I'm hinting at here is, and I'm again going to Manya's question, the collusion between the corporate agents, the corporate sector, and the state is very big. And in terms of getting access to COVID vaccine, I do not think there is too much of there is too much to say that people who are not even recognized as citizens of the country would get access to the medicine. I'm not very positive on that front, because it's not that I do not want to be hopeful. I want to be hopeful, but the reason is I'm skeptical about it, because the way the state, the system is structured, the very structure discriminates between people, the very structure discriminates between populations, and the very structure discriminates against the interests. So that's why I'm quite skeptical about the access of medicines to the poor and to the marginalized and to the stateless people.
Thank you, sir.
Thank you so much, sir. So now we'll move on to the next speaker, Miss Elena, who is a assistant professor of international law and international relations in University of Rey Juan Carlos, Madrid. So she will be speaking on the topic, the legal value of the decisions making by the World Health Organization in cases of pandemic, obligations and responsibilities. I hand over this mic to ma'am. Ma'am, please.
Thank you very much. Can you hear me?
Yes, ma'am, we can.
Okay, so before anything else, thank you very much to invite me to participate here because it's a pleasure for me. As you said before, I am going to speak about the value, the legal value of the decision making by the World Health Organization. As you know, this organization is an international organization of a universal nature and also compose the so-called United Nations system. Before analyzing the legal value of the decision making by this organization, I would like to highlight some important things about this international organization. I think these relevant issues are important to understand the legal value of the decision making by this organization because are related to this. The first one is that the World Health Organization has played an important role in the process of international organization configuration. So it is true that the constituent treaty of this organization came in force in 1947, but the origin of this international organization are placed at the beginning of the 20th century. So in this sense, we could point out three significant dates. In the one hand, in the context of America, which is an important continent related to the configuration of the international organization, it was created the called Pan American Health Office. So it's the first origin of the World Health Organization. The origin of the Pan American Health Office was in 1902, so in the last century. In another hand, in 1907 in Paris, it was created the International Health Office, and also in the end, in the interwar period, in the framework of the League of Nations, it was created another International Health Office. So I think it is important, it is relevant to observe that during a period of time, two universal health organizations exist. Then they are unified, and it is the origin of the World Health Organization after the Second World War. Also, it is relevant, as I said before, to highlight the important role of America or the American continent in the process of creation of international organization. So there appeared the first health office, which remains nowadays as part of the World Health Organization as a regional office. The second important thing I would like to highlight is that the World Health Organization is a truly international organization from an international law perspective. What does mean? Does mean this organization have the element to be considered as an international organization from an international law point of view. As you know, these elements are four. The first one, it is a group of states. The second one, it is composed or there is a constituent treaty. The third one, there are permanent body. And the last one, this organization or this group of states created by a treaty has a legal personality. So has a own will different from the state which compose this organization. In the case of the World Health Organization, the constituent treaty, as you know, it is called the World Health Organization Constitution. And also, this organization is composed by permanent bodies. As the main bodies which compose this organization, we can mention, on the one hand, the World Health Assembly, and on the other hand, the Executive Board. Just to know a little bit more about these organs, we are going to refer to the main function of both of them. On the one hand, the World Health Assembly, as you know, and as it is said by the own World Health Organization, is the decision-making body of the organization. It is attended by delegation from all World Health Organization member states and focuses on a specific health agenda prepared by the Executive Board. The main function of the Assembly are to determine the policies of the organization, also appoint the director and supervise the financial policies, as well as review and approve the proposed program budget. So, in the other hand, related to the Executive Board, it is composed, as you know, by 34 technically qualified also members elected for 3 years terms. The main function of this organ are to implement the decisions and policies of the Health Assembly, and also advise to facilitate the work done by the Assembly. There is no doubt yet then that the World Health Organization is a truly international organization, because this organization has the element to be considered as an international organization. Also, this organization, as I said before, has a universal nature, which is very important because it's an organization specialized in the field of health and with a universal nature. However, this organization, it is not an organization of integration, and it could be, I don't want to see a problem, but it could be an issue maybe related to the legal value of the decision making by this organization. As you know, this organization is an international organization of cooperation. So that means that the member state, so the state, retained the sovereignty and the power, we can say. Not all the power, but the majority of the power. This feature of the organization has an impact on the legal value, as I said before, of the decision making by the World Health Organization that we are going to analyze later. The third important thing before analyzing this value, this nature of the decision making by this international organization, is that for many years, the World Health Organization has fought against pandemic. So before highlighting the result or the main result in this sense, it is important, I think, I thought was interesting to clarify the difference between outbreak, epidemic, and pandemic. So the three of them are, we can say, disease, but each has their own element, their own characteristics. So we can say that the outbreak is an increase in the number of endemic cases. It can also be a single case in a new area. If this outbreak, it is not quickly controlled, an outbreak can be an epidemic. So we can see already the element which define the outbreak. On the other hand, the epidemic can be described in a different way. It is a disease that affects a large number of people in a community, population, or region. I think it is important to make this different because we are going to see later how the World Health Organization has fought against each of them. And the last one, the pandemic, can be described as an epidemic that spread over multiple countries or continents. And I think this is the main feature which describes the pandemic. So it is over different countries, over different continents. Some examples could be, even if we are going to speak about this thing later, but some examples of each of the disease we just mentioned could be, for example, the coronavirus as a pandemic, the Ebola or cholera as an outbreak, and also the tuberculosis as an epidemic. However, as you know, it is a theoretical distinction, so in the practice, sometimes it is difficult to distinguish one from another because we have to take in account different elements and also different factors, different moments. So that is the reason why if you check the website of World Health Organization, for example, the Ebola, it is described as epidemic, but also as an outbreak. So depend of the moment, depend of the factors. Anyways, the World Health Organization has fought, as I have already said, among others, against the 4 diseases mentioned. So I remember it, the coronavirus, the Ebola, the cholera, and the tuberculosis. And we are going to study a little bit just to analyze briefly the main measure or some of the measure taken by this organization to fight against this disease. Related to Ebola, as you say, and also as it is said by the World Health Organization, the Ebola is a severe, often feral illness affecting humans, and this virus is transmitted to people from wild animals and the spread in human population through direct contact with the blood, secretions, organs, and other fluids of infected people. This disease is very, we can say, the international society is very was and also is very worried about it because it was there were detected many cases. A lot of them in Central Africa, but also in other parts of the world. It is true that it is remain, but as the organization said, just not longer time ago, the 10th outbreak of Ebola in Democratic Republic of Congo has been declared over, thanks in large part to the leadership and commitment of the government with support from the World Health Organization. I think this declaration made by the own World Health Organization is very important because it is show how important, how relevant is the cooperation between the government, the international organization, the private sector, also the civil society. So I think it is relevant to note this state made by the international organization, by the World Health Organization, because show an important thing to achieve or to combat the disease and to fight against them. Related to the tuberculosis, as it has been described by the World Health Organization, tuberculosis is an infectious disease caused by a bacterium, as you know, that affect different parts of the body. For example, or such as the brain, the heart, the bones can be affected. Zimbabwe was very, we can say, worried about this disease because many cases were found there. So just to note something about it, about 30,000 people in Zimbabwe fall ill of tuberculosis, so a cause of this disease. Tuberculosis is not yet over as the rest of the disease, but as it was pointed out in a report of the World Health Organization, the 2019 World Health Organization Global Report reveals that Zimbabwe is making progress to end the tuberculosis. So it is there yet, but it is making a progress to end it, thanks to the help also of the World Health Organization. So again, we can see a key role of this organization fighting against disease. Related to the cholera, as we observe in the case of tuberculosis, cholera is not yet end, but the World Health Organization states that the organization continues to provide leadership and support for activities with health authorities and partners to respond to this ongoing cholera outbreak, including case management, laboratory investigation, hotspot making, and vaccine. So in different ways, the World Health Organization is helping to control and also to end this disease around the world. And the last one is the coronavirus. Related to the coronavirus, the World Health Organization also has played a very important role, as well as in the fight against another disease. In this sense, the World Health Organization has adopted many decisions and also various or several strategies. Later, we are going to analyze the legal value of this decision. But anyways, the international organization, the World Health Organization, has played an important role in fighting against this disease. The content of the decision making by the organization and also the strategies are very interesting. However, as it is said at the coronavirus strategy update, which was updated at the April 2020, just some months ago, this document said that the purpose of the document is to help guide the public health response to coronavirus at national and also subnational levels. Apart from that, this document also said that it is important to update, to translate knowledge accumulated since the publication of the strategic and response plan on February 2020 into additional practical guidance for whole of government and whole of society strategic action. So what does mean? Does mean that even the content of this document are very important. We can see as it is a guide to the state. I mean, it is not a binding instrument, or there are not binding instruments. They don't have a binding nature. So we cannot say it is not important, but because it is not true, but they speak about a guide, about a help guide. So it's just the guidelines to the state, but they don't impose obligation to the state. So of course, the effort made by the World Health Organization in order to combat the coronavirus has been huge. We cannot have doubt about it. However, as we can observe, and as I have just said, the majority of the decision and strategies adopted by the organization don't have a binding nature. Later, we are going to also analyze what happened with the constituent treaty of the organization and also the health regulation that was adopted by the World Health Organization. Maybe it's different, or maybe it is the same, or we find the same. But before that, I would like to summarize. I know there is a lot of information about it. You can take it if you want more information at the website of World Health Organization. But I would like to summarize, like briefly, the World Health Organization action since the coronavirus was known, more or less. And we are going to follow the chronological scheme indicated by the own World Health Organization in its website. As I had already said, if you want to take more information about it, you can just see the website. You can also find there something that is interesting, I thought was interesting, an interactive version of the fact of the action. So you can find like every action almost every day from December to nowadays today. So I would like just to highlight, because if not, I don't have time to do it, but I would like just to highlight the most important, or the event that I consider most relevant. So the first one I would like to say it was the 31 December of 2019, when China report, we can say the first cases of pneumonia. They didn't know yet that was coronavirus in the region. So after that, just one day later, the 1st January 2020, the World Health Organization had set up what is called the Incident Management Support Team across the 3 levels of the organization. So the headquarters, the regional quarters, and also the country level. And I think that is important. In this moment, the organization putting this plan, this incident management support teams, putting the organization on an emergency footing for dealing with the outbreak of coronavirus. So just one day after China report the first cases of pneumonia, we can say it, the World Health Organization began acting. After that, as I already said to you, you can check every day at the website, but I am just highlighting the most important event. So the 10 January 2020, the World Health Organization adopted a guide, a technical guide online with advice to the country, to the international organization, to the civil society in general. Again, we can see, we can observe how is considered, or how we can describe from a legal point of view the action of the World Health Organization. Again, in this case, the World Health Organization adopt and guide to the state. So it is not an instrument with a legal nature in case or in terms to combat pandemics. Also, in January 2020, I mean, just 3 days later, it is confirmed some cases of coronavirus outside China. So the World Health Organization began to be more worried about it because maybe at the beginning it was considered as an outbreak, but if, as we said before, as we studied before, if it is disease in different countries or over different countries, it could be considered as a pandemic. So in this case, the World Health Organization became worried of that. Just 1 day later, 14 January 2020, the World Health Organization note, thanks to the scientific and technical expert, that it could be a risk that the coronavirus could be transformed, we can say it, I mean, of a possible wither outbreak. So as we said before, at the beginning it was considered as an outbreak, just concentrated in a region, and then the World Health Organization started thinking that could be a wider outbreak or even be considered as a pandemic. So almost at the end of January 2020, and this is very important, the World Health Organization began to consider the coronavirus as a public health emergency of international concern. However, what happened at this time? It was not a consensus around the world to consider the coronavirus as a public health emergency. So in this moment, it was on the table, but there was not a consensus to finally consider the coronavirus as a public health emergency of international concern. We have to wait a little bit more. The 24 January 2020, it was confirmed the first cases in Europe, in the European region of the World Health Organization. So France, if I am right, report the first cases of coronavirus. Also, and that is important as well, because we mentioned this office and this organization before, the director of Pan American Health Organization urged countries in Americas to be prepared in case to outbreak of coronavirus, and also to be prepared to detect early the cases. So we can see the cooperation, the necessary cooperation. Another important date, and I will say one of the most important ones, it will be the 30 January 2020. In this case, there was a consensus to consider, so just some days later, as you can say, it was a consensus around the world to consider the coronavirus as a public health emergency of international concern. It is important because we can say how the international community taking account, it is an important thing, and we have to fight against it all together, but also because it is the sixth time, so the sixth time that the World Health Organization has declared a public health emergency of international concern since the international health regulation came in force in the year 2005. So just 6 times in the history of the World Health Organization, it was declared a disease as a public health emergency of international concern. So I think we have to remember this date because it's important in the history of the World Health Organization and also in the history of the international relation in general. An also important date, apart from the date we have just mentioned, is February 25, if I am right, 25 February 2020, because it is confirmed the second case of coronavirus in the African World Health Organization African region. So we can say how it is transformed the disease from an outbreak to a pandemic. Also in March, the World Health Organization made an assessment, we can say it, that the coronavirus was considered as a pandemic. So we have already studied, analyzed each moment and the evolution, how it was considered at the beginning as an outbreak, and then the 11 March 2020, the World Health Organization said the coronavirus is a pandemic. So it is already affirmed by the organization. Also in March, we can analyze together several events which were on, because they show the cooperation, the necessary cooperation, as we already said, between the different levels of the international society. For example, it was adopted and solidarity response fund, donation from private individuals, corporations, and institutions. So from this moment, I think from the beginning, but above all, we can say from March, the World Health Organization is aware that it is important a cooperation between different levels of the international society to fight against the coronavirus, because it is declared, remember, on March 2020 as a pandemic. So the first level, or one of the level, if you want, it will be the cooperation with and from the private sector. So donation from private individuals, companies, and corporations. Also, in March as well, it was adopted a global humanitarian response plan. And in this plan was adopted thanks to the cooperation between the World Health Organization, but also other international organizations, such as, for example, the United Nations as the main universal organization, if we can say it like that, and also European Union, that I think has an important role also in fighting against the coronavirus. This cooperation can be researched at the, we can say, national level, or in the framework of a summit composed by a state. I am speaking about the G20 summit. In this summit, also, it was research and agreement to cooperate in fighting the coronavirus. And another example of this necessary cooperation will be that the World Health Organization called on countries to work with companies to increase production, to ensure the free movement of essential health products, and also to ensure the equitable distribution. So as you can see, there are different levels of cooperation. All of them are necessary to fight, to combat the disease, the coronavirus in this case. After March, in April, and I am going to finish soon, in April, the World Health Organization showed some consequences of the coronavirus. I just highlight one of them because I thought was interesting. This consequence was the violence against women. How coronavirus can increase the violence against women. Well, it was just we can say and briefly comment of the I think the most important event or action taken by the World Health Organization in order to fight against coronavirus. As I have already said to you, you can take all of them at the website. So I just highlight the most important one from my point of view. In order to finish, I would like, well, we cannot finish or we cannot end without mention the most important legal instrument related to the health in the framework of the World Health Organization. On the one hand, as I have said before, we can find the World Health Organization Constitution. And on the other hand, we can find the regulations or the World Health Organization Reglement, which it is called, the official name, it is the 1969 International Health Regulation. So apart from the strategy and also the decision making by the World Health Organization, the two most important legal instruments the organization has are the World Health Organization Constitution and the World Health Organization Reglement. Which is the issue related to this instrument? Well, both of them are binding instruments. I mean, the first one is a treaty which creates an international organization that is the World Health Organization. And the second one, it is also a binding instrument. But the problem, if we can say like that, is that if you read this instrument, if you observe the content of this instrument, you will see that they don't impose a specific, concrete obligation, just general one. So the thing is that even if both instruments are binding, have a binding nature, which is very important, and also they have like a universal nature, they don't impose a specific obligation to the state. So that means the majority of the decisions which come from this instrument are recommendations to the state. In conclusion, the World Health Organization action combating pandemic have been very important, as we just studied, analyzed, and also very relevant. Without an international organization, also universal organization as the World Health Organization, the fight against disease will be very complicated in the current international society. However, the cooperation nature of this organization and also the power which are left to the state doesn't help to achieve a global strategy in order to end with pandemic as the coronavirus or cholera, for example. We need, I think, more binding instrument at the international level, as well as a better coordination between the international organization, both the regional and the universal ones. The implementation of the World Health Organization measure and recommendation remains in the hand of a state or in the hand of the integration organization such as the European Union. However, I think that this kind of organization of integration, such as the European Union, have not adopted sometimes the necessary measures to ensure a same line or a same course of action in order to combat the transmissible disease. Although usually there is a coordination between states, that is true, in the framework of the International Organization of Integration and also International Organization of Cooperation, an example of a lack, we can say, of a means, of a same line of action in order to combat the pandemic, for example, could be the measure taken during the containment, adopting during the current pandemic. So, to sum, in conclusion, we can say that, of course, the international organizations such as the World Health Organization have making a lot of effort to combat the disease, and also they are achieving a lot of we can say importance the improvement, but we need, I think, more binding instrument to limit the power of the state and also to achieve more improvement in the current international society. Thank you very much.
Thank you so much, ma'am. It was really, really very informative. So I would like to open the floor for questions. If anyone have a question, please raise the hand.
I think Ramim has question. Ramim, please.
Hello, good afternoon, everyone. This is Muhammad Ramin. I'm from Afghanistan. So I want to ask a question. As we know, many countries are trying to make the COVID-19 vaccine. So my question is, what is the process and condition of WHO for specific one of these vaccine for all whole world?
I cannot hear very well. Sorry about it. Thank you for your question.
Welcome, ma'am. If you didn't get, I will ask again.
Yes, please.
So as I said, as we know, many countries are trying to the COVID-19 vaccine. What of the process and condition of WHO to specific one of these countries vaccine for all whole the world?
Okay, thank you very much. Thank you very much. So I think the World Health Organization, as I don't know if I said, but I think there is like the main role is a role of coordination. So the problem is, even if the World Health Organization follow the progress making, but I think it was the question. If I am wrong, tell me please. So even if the World Health Organization like control, we can say the measure taken by a state, then the state have or in the hand of states remain the power to take the measure to combat the pandemic or the disease. So I think the World Health Organization is a very good thing because it has a universal nature. So, but it is like the role, the main role of this organization is just coordinate, because it is a international organization of cooperation. So even if it is it make some decision, and also we cannot forget that in world the World Health Organization also have made related to the coronavirus, but also in other crises or healthy crises, have made some resolution, for example, that we can think that are binding nature. But then if you observe the content of this instrument, they are just like a recommendation to the state. So I think that is the also the European Union, as I said before, even if it's an international organization of integration, at the beginning of the coronavirus, I think nowadays it's a little bit different because there is a strategy or global strategy in the European region or in the framework of the European Union for the member state. But at the beginning, as I said at the end of my speech, it was not an global strategy in the framework of the European Union. So what happened? For example, Spain was like a hard containment, but for example, UK or France didn't have it. So I don't know if I am answer your question, but in general terms, we can say that to control the measure adopted by the countries, the World Health Organization has some we can say some ways, but the sovereignty and the power remains in the hand of state. Thank you. Ramin. Thank you. Thank you, Ramin.
Thank you so much, ma'am. I would like to have another question from Avantika Banerjee.
Hello,
Not
ma'am.
difficult, I hope. Avantika. Hello.
Hello, ma'am. Actually, I wanted to ask that recently there was an action initiated by Australia, backed by USA and some other countries, including India, that they wanted to conduct an investigation in the wet market of China. To which China very easily said that once the world right now has to deal with the coronavirus, and once we are done with it, we can investigate it later, investigate the wet market later. And as we know, World Health Organization did not say anything about it, whereas the major countries wanted the investigation to be done right away. So does the World Health Organization have any kind of power in that situation where it can ask China to let the investigation happen anyway?
Thank you very much, Avantika. So a very interesting question and also very difficult one. So I don't know if I can answer you like properly or with all the elements, but I will try. I mean, as you say, of course, some countries want like to investigate not the conduct of another countries, mainly China, for the coronavirus. I think in this case, I mean, I think the just is an idea and an opinion, but I think nowadays in this moment, the international society is worried about how to end the health crisis, how to combat the coronavirus, because it is not yet end. So I think that is the first thing which worried the international society or community nowadays, in these days. After that, I think some countries, as you said, are going to ask for responsibility. But as you know, Avantika, I mean, in the framework of the World Health Organization, of course, it could be like, or it could be begin an initiative to ask for responsibility, but also I think it is necessary and cooperation with other international organizations. For example, United Nations as a whole, I mean, has an important role in this sense, but also other international or regional international organizations such as European Union, because it's like the representation of some or a part of the continent, no? So I think, Avantika, of course, after the crisis or when the crisis it will be controlled, we hope it. So the international community will ask for responsibility, but I think it is necessary and cooperation, again, cooperation between the different level or also the different kind of international organization. Thank you. It was a very interesting question, but very difficult one.
Thank you so much, ma'am. I would really like to move on to the next speaker. So
Perfect.
I would like to introduce Mr. Harold, who is a professor member in the Cuban Society of International Law, who will be speaking on state responsibility during pandemic. So please, I hand over the mic to you. Mr. Harold? Hello, am I audible?
Yeah,
Yes,
you
you are audible.
are audible. Let Sarah joined. I think you might take 1 minute.
Okay.
Hello?
Yeah, hi, sir.
Hello?
So your voice is echoing a lot.
Can you hear me, please?
Yes, sir, we can. Now it's fine. Yes, sir, please.
Can you hear me, please?
Yes, sir.
Yes?
Yes, sir, you are audible. You are audible, sir. Please
Thank
start.
you. Thank you very much. Thank you very much.
Most
It's
welcome,
a
sir.
pleasure to participate in this event. I want to thank to INRA. Well, I'm going to talk about the state responsibility in the field of human rights in times of COVID, special reference to the Inter-American human rights system. Right?
Yes, sir.
Yes, sir.
Thank you. Well, in this presentation, I will expose an overview of the fundamental aspect in current time about a particular region of the world. It is about the American continent and how the regional system for the protection of human rights has reacted to the pandemic to establish and clarify the obligation of a state within the framework of the aforementioned system for the protection of human rights. In other words, a clarification of obligation of staying in time of COVID within the framework of the Inter-American human rights system to avoid state responsibility. To understand the problem associated with the state responsibility that derive from obligation that state have agreed to protect and guarantee human rights and the particularity of the obligation in this current time of pandemic, we must first analyze which are the characteristics of the Inter-American system and what have been the standard set to protect human rights in this time of pandemic. Therefore, we divide this presentation into two parts. The first part in which we analyze the fundamental characteristic of the Inter-American human rights system, and a second part, and we will focus on the main human rights standard established in this system in the time of pandemic. The construction of the Inter-American system has a moment of the particular importance in the American Declaration of Rights and Duties of Men, approved at the 19th International American Conference of Bogota, which had and is immediate precedent the Inter-American Conference of the Problem of War and Peace of Mexico, where the Inter-American Juridical Committee was entrusted with the draft resolution on the subject. In that conference, the Organization of American States would also be born. Years later, the American Convention of Human Rights was adopted in 1969 by some states of the American continent. In this sense, the American Declaration, the Charter or UAS, and the American Convention have come to form, as Thomas Borgenthal reminds us, and single corporate juris, which is nothing more than inter-American human rights law. In this sense, the existing inter-American system for the protection of human rights is the product of a process in which the mechanism for the protection of rights have been improved and the content of various human rights has been expanded. We found an institutional dimension with the Commission of Human Rights and the Inter-American Court of Human Rights. We also have a substantial dimension, not only in the American Convention of Human Rights, but also in other conventions, such as the Inter-American Convention to Prevent and Punish Torture, the Protocol of the American Convention of Human Rights, relative to abolition of death penalty, the Inter-American Convention to Prevent, Punish, and Eradicate Violence Against Women. This convention is now like Convention of Belém do Pará, among others. At this point, we will focus on the two fundamental organs of the Inter-American system for the protection of human rights. First, the Inter-American Commission. His organizational element, function, competence, and the procedure of the Commission as regulated in the American Convention of Human Rights. The main function of the Commission is to promote the observance and defense of human rights. Its function and competence include making recommendations when it deems appropriate to the governments of the member state to adopt progressive measures in favor of human rights within the framework of the domestic law and constitutional provision, as well as provision appropriate to promote due respect for those rights. Also prepare the studies and report that it deems appropriate for the performance of this function. Requests the government of the member state to provide it with report on the measure that they adopt in the area. To attend to requires that through the general secretary of the Organization of American States, the member state, they may formulate on matter related to human rights. Also, to render an annual report to the General Assembly of the Organization of American States, among others. The convention establishes that the Commission was competent to receive petitions presented by any person or group of persons of non-governmental entity legally recognized in one or more member states of the organization that contain denunciation and complaint of violation of the convention by a state party, as well as to receive and examine communication from a state party. That is in time of deposit of the instrument of ratification or accession, or any time thereafter. It declared recognition of the Commission competence. That is alleged that another state party has committed human rights violation. In relation to the Inter-American Code, we can say that is regulated in the American Convention of Human Rights, or Pact of San Jose. The Inter-American constitute an autonomous judicial institution with the objective of applying and interpreting the American Convention of Human Rights and exercise its jurisdictional function and an advisory function in accordance with the Article 61, 62, 63, and 64 of the Convention. In general terms, the court has a contention jurisdiction and an advisory jurisdiction. Is a provisional measure and has a mechanism for supervision of sentence. First, I will expose the pronouncement of the Inter-American Court of Human Rights. As the pandemic spread across the American continent, the court released Declaration 1 of the 2020 of April 9, entitled COVID and Human Rights Problem and Challenges must be addressed with a human rights perspective and respecting international obligation. In this declaration, the court recognized the extraordinary problem and challenges that the American state, society as a whole, and each person and family are facing as a consequence of the global pandemic caused by the coronavirus. For this reason, is a declaration to urge to adoption and implementation of measures within the strategy and effort that the state party to the American Convention of Human Rights to address and contain this pandemic that concerns life and public health. In this sense, the court states that all these measures to be implemented by the state be carried out within the framework of the rule of law, with full respect for the Inter-American Instrument for the Protection of Human Rights and the standard development in the case law of the court. For this reason, the court exposed several considerations that I present below. In the first place, the court understands that the extraordinary problem and challenges caused by this pandemic must be addressed through dialogue and joint international and regional cooperation, solidarity, and transparency amongst all states. For this reason, multilateralism is essential to coordinate regional efforts to contain this pandemic. The court also considered that the multilateral organization, whatever their nature, should help and cooperate jointly with the state under a human rights approach to seek solutions to present and future problems and challenges that the present is causing. The court also considered that all those measures that the state adopt to deal with this pandemic and may affect or restrict the enjoyment and exercise of human rights must be temporarily limited, legal, adjusted to the objective defined according to scientific, reasonable criteria, strictly necessary and proportional, and in accordance with the other requirement development in Inter-American human rights law. The court also considered that the state must ensure that the use of force to implement containment measures comply with the principle of absolute necessity, proportionality, and the precaution according to the jurisprudence of case law of the Inter-American Court. I will also focus in a special way that the court understands that given the nature of the pandemic, economic, social, cultural, and environmental rights must be guaranteed without discrimination to everyone under the jurisdiction of the state, and especially to those groups that are disproportionately affected because they are in situation of the greater vulnerability, such as the elderly, girls and boys, persons with disability, migrants, refugees, stateless persons, persons deprived of liberty, etc. In all of this, the court insisted that at this time, a special emphasis should be placed on guarantee in the timely and the appropriate manner the rights to life and health of all persons under the jurisdiction of the state without any discrimination, including the underlying migrant, refugee, etc. It was also important that the court considered that the right to health must be guaranteed, respecting human dignity and observing the fundamental principles of biotic, in accordance with inter-American standards regarding their availability, accessibility, acceptability, and quality, appropriate to the circumstances generated by this pandemic. Therefore, health workers must be provided with supplied equipment, material, and instruments that protect their integrity, life, and health, and that allow them to perform their work in reasonable terms of safety and quality. The court also considered it appropriate to take into account the situation of women and the violation of them in moments of confinement. For this reason, it considered that given the measure of social isolation that can lead to exponential increase in violence against women and girls in their home, it is necessary to emphasize the state duty of strict due diligence regarding the rights of women to life, a life free from violence. Therefore, all necessary action must be taken to prevent cases of gender and sexual violence, have safe mechanisms for direct and immediate reporting, and strengthen care for victims. Another aspect that the court mentioned that's related to the situation of the prisons. In this sense, the court considered that given the high impact that COVID may have on people deprived of liberty in prison and other detention centers, in view of the patient position of the state guarantor, it is necessary to reduce the levels of overcrowding and to provide a rational or ordinal manner alternative measure to deprivation of liberty. As the court was aware of the number of problems that this pandemic will cause in employment, it also considered clarifying the obligation of a state in this matter. In this sense, the court considered that it should be ensured that source of work are preserved and that the labor rights of all workers are respected. Likewise, measures must be adopted and promoted to mitigate the possible impact on the source of work and incomes of all workers and ensure the necessary income for the subsistence in conditions of human dignity. Due to the measure of social isolation and the impact that this generates on personal and familial economy, mechanisms should be thought to meet the basic provision of food and medicine and other basic needs to those who cannot carry out their normal activity, as well as to the homeless population. The court also took into account the importance of the internet at this time. Therefore, the court states that access to truthful and reliable information as well the internet is essential. Adequate measures must be in place so that the use of a good technology to monitor and track the spread of the coronavirus is limited and proportional to health need and doesn't imply an excessive interference and harmful to privacy, the protection of personal data, and the observance of the general principle of non-discrimination. In the field of the justice system, the court considered essential that access to justice and complaint mechanism be guaranteed, as well as particularly protected activity of journalists and human rights defenders in order to monitor all those measures that are adopted that affect or restrict human rights with the aim of gradually evaluating their compliance with inter-American instrument and standard, as well as their consequence for people. Lastly, the court states that it is pertinent to alert the competent bodies of agency to combat xenophobia, racism, and any other form of discrimination, so that the state taking extreme care so that during the pandemic, no one promotes outbreak of this nature with the fake news or incitement to violence. In this way, the court already has important pronouncement on case submitted to the court in relation to the coronavirus pandemic, especially in terms of provisional measure, also decision adopted by the court in the stage of the supervision of sentence. Example of this case as Vélez Eldor versus Panama, also case of Miguel Castro versus Peru, and others. At this point, I proceed to analyze the pronouncement of the other fundamental organ of the Inter-American human rights system, as we already know, the Inter-American Commission on Human Rights. On March 27, the Commission installed the timely and integrated response and coordination room for the COVID to strengthen the institutional capacity on the Inter-American Commission of Human Rights to the protection and defense of fundamental freedom and human rights in this context, especially the right to health and other rights related with social and cultural and economic sense. One of these main contributions from resolution number 1, entitled Pandemic and Human Rights in the America. In this resolution, a call is made to the member state of the American organization to immediately and transversally adopt an approach centered of human rights in any strategy, policy, or state measure aimed and confronted the COVID pandemic and its consequences, including the plan for social and economic recovery that are formulated. The resolution states that this plan must adhere to unrestricted respect for inter-American and international standards of human rights, particularly the human rights related with the context, social and economic. In a special way, this resolution referred to groups in a special situation of the vulnerability, such as the underlying people private of liberty, women, indigenous people, people in a situation of human mobility, children, and adolescents, etc. In this month of pandemic, the Commission has done a good job within the framework of his competence in the protection of human rights. It has had important pronouncement in this sense, with a special mention to the state incorporating the gender perspective in the response to the COVID pandemic and to combat sexual and intra-family violence in this context, to the protection of human rights of migrant, refugee, and displaced persons in the face of the COVID pandemic, regarding restriction on freedom of expression and access to information in this response of a state to the COVID pandemic. In relation to the rights of the people LGBT, regarding to rights of the elderly, of the consequence of the COVID pandemic in girls, boys, and adolescents, with respect to the rights of Afro-descendant people, and to prevent racial discrimination in the context of the pandemic, among others. We can say then that among the lasting contribution of the Commission in this month is resolution number 4, entitled Human Rights of People with COVID, adopted on July 27th. It's a resolution that contains inter-American guidelines of the human rights of people with COVID, prepared by the coordination room for timely and integrated response. In this sense, we find guidelines of the protection of the right to health of people with COVID, of the protection of the right to free, prior and informed consent of people con COVID, on the protection of the right to equality and non-discrimination of people with COVID, guideline for the priority of the life of people with COVID in public policy, resource and cooperation, guideline of the protection of the rights of people with COVID in relation to the intervention of private actors of company in the field of health, of the protection of the rights of access to information of people with COVID, a guideline of the protection of the rights to the confiability, privacy, and use of personal data of people with COVID, of the protection of the rights of health and care workers who care for people with COVID, on the protection of other human rights related with the economic and social sphere, the protection, insisto, of the access to justice for people with this COVID. In general, I wanted to set out in general way the main concern of the fundamental organ of the inter-American human rights system in times of this pandemic. As a conclusion, I can say that the response of the main organs of the inter-American human rights system within the framework of their competence has been outstanding in the face of the current challenges caused by the pandemic. The work of this body in setting human rights standards in the middle of this pandemic has called on the state about the action to be taken to guarantee and protect the human rights of people in this difficult situation. These are difficult times, and we require everyone's effort to return to normality. And in this sense, it is up to the human rights defender, jurists from around the world to join force so that human rights can be respected and guaranteed in this difficult time of the pandemic. I hope so. Thank you very much. If you have any question.
Thank you so much, sir. I now open the floor for questions if you have any question.
Ma'am, I have a question.
Yeah, please go on.
Actually, sir, whenever we talk about or learn about state responsibility, we are taught that state is responsible for the conduct of its citizen. Now, my question goes two part, wherein in USA we have seen that after the beginning of the pandemic, in the court of Texas and in the court of Missouri, right? The litigations were given that people said that their right and freedom are being they are not given their freedoms properly, because they were being asked to deal with the pandemic situation. They were asked to self quarantine themselves, wear masks, so they thought that it was against their right and freedoms, right? And they were also supported by many churches and religious group in doing this. So my question is the judicial body and is the religious body accountable for their actions under international law? Because of these bodies and these organizations, the multiplication of diseases in USA has been increased. So that is what I wanted to ask. How can we book institution like the religious group and the judicial bodies for multiplication of the disease?
Yeah, thank you for your question. But I understand you you have a question about the impact of the decision of the fundamental organ in international law. Yes?
Yes, yes, sir.
Yes. All organ in international law act in the framework of their competence. The international law is a field of the law very limited. If we compare with the other field of law, no? I think the law that born in the national court and national organs, wherever they are nature, political nature or juridical nature. So the international law has a limited function in the international relation and the protection of human rights. We can say that no, I can say that international law is not important for the life of people in our world, but their function, and their action is limited by their competence. But the Inter-American system has an important role to protect the human right in the American continent, because they set out a standard for the state, and the state has the obligation to see to comply with the standard established by the organ in Inter-American system. So in American continent, we have a lot of examples that we can say important relation of the inter and national court and organ to apply and to protect the human rights. I don't know if I respond to your question.
Yes, sir. And yes, sir, that was my question, that if in a nation there is this problem created by their religious group and their other bodies, judicial bodies or any law enforcement bodies, so how can the international body react to it? So my question has been answered. Thank you so much.
I understand what is you exactly said about the group.
So I said that, sir, actually what I've read till now about the international responsibility, state responsibility, is that state is responsible for the conduct of its citizen. In view of this, I was asking that when the pandemic began in the month of April, I guess, there was a multiplication of suits in the state of Texas and in the state of Missouri in the USA, wherein people said that their right to freedom, freedom of their freedom and their other rights have been curtailed off by the government, and thereby there was a multiplication of cases in America. And this kind of protest was supported by the churches also, the other religious groups also, and neither of the law enforcement bodies tried to stop this. So all I was asking was that whether the state, in the view of international law, does it have any kind of obligation to stop these religious groups, this law enforcement groups, or ask its citizens to not to file futile case laws in the judicial bodies? Because pandemic is a situation in which even if just one person is infected, it can create a lot of mess. So can a state ask its citizen, in the interest of the international law, to follow the guidelines and the rules?
Yes. No, no. In American continent, this organ of the Inter-American system has established obligation to all states respect to protect different group in the society. All measures that limit the freedom or measure of confinement must be under the rule of law, and the state have the obligation to implement this measure under the rule of law. That is not only because the constitution, the national constitution, establishes those standards for the organ, for the national organ. If I say the Inter-American system, the fundamental organ in Inter-American system has established fundamental guidelines for the state in the time of to implement or apply this measure for all group, okay? Girls, women, against the sexual violence, etc.
No, thank you so
Thank
much,
you,
sir.
sir.
Yeah. Any more question? Do we have any more question? So yeah, so in case there is no question, I have a question to ask, sir. Since this is a very established fact that the responsible state behind the outbreak of this pandemic is China. So what exactly is the kind of state responsibility does China have at international stage? How is it accountable?
But China is has a responsibility with another state in this field. But I said I focus my analyze in the state responsibility in the field of international law. But if you question the question follow the way of the responsibility of China in the spread of the pandemic, no? Well, I said that we need to have a lot of time to analyze with intelligent those months and the situation that has outcome in this outcome. Sorry, we need to have a lot of time. I say again, we need to a lot of time to have a real perspective about what happened. What is the real responsibility of China of the spread of the coronavirus? What is the responsibility of the organization of the other organization, like the health organization? But I don't know what to say. I don't have all elements to have what is the guilty in this problem. We need to have a lot of time.
Yeah. So thank you so much, sir. So I'll be having one more question from Brenda. Yeah, Brenda, please go ahead and ask the question, please.
Thank you. Nowadays, and especially in the American region, for example, the protection of the human rights, especially the DESCA, during the pandemic need international cooperation. In this sense, I would like to ask if we could affirm that the international cooperation exists as an international obligation in the framework of the Inter-American human rights system, and in consequence, if this obligation is exigible before some court or is merely of a voluntary nature.
But the international law in America has a relevant particularity and has a development different with the other development in the other areas of the international law. the cooperation principle has a important situation in this continent, because we can understand this principle like the fundamental principle to organize the other principle of the norm or rule of the international law in the continent. Exactly, we can say that the principle of cooperation has a principle that we have seen with a principle that obligate to a state and enforcement the state like other rules, but this principle must be a guideline to the state to implement and to apply the standard for the protection of human rights, to establish a good economic relation, a good economic, a good social relation between all states of the continent. That is a principle have established of the principle of the main charter of the many organizations in the continent. That the principle of cooperation has a particular and importance very strengthened in the American continent. I don't know if I respond to your question.
Yes, thank you.
Thank you so much for the question, and thank you, sir. Thank you so much. Is there any more question that you would like to question, sir? So yeah, I guess we are done. Thank you so much for this session, sir. I would like to thank all the three speakers, and I would like to thank all the participants who have actively participated in this session. And we will be meeting tomorrow again.
Thank you.
Welcome, sir.